All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this Honorable Court. This Honorable Court is now in session. Please come to order.
Morning, Your
Good
Honors.
morning.
Good morning.
Good morning.
Welcome to the District of Columbia Court of Appeals. We are appearing virtually this morning on Zoom, streamed to YouTube. If we have any technical difficulties, don't worry, we'll regroup and get back up online. These things do happen on occasion. So we have one case on our calendar today. Bobby Johnson versus United States, 17 CO 95. It's a consolidated case. It's consolidated with 19 CO 890. We do have a third member of our panel, the Chief Judge, but she will be listening to this argument on the tapes. So with that, counsel, when you are ready, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Good morning, Your Honors, and may it please the court. My name is Emily Cuniff, and I am appointed counsel for Mr. Bobby Johnson. I would like to reserve 3 minutes for rebuttal. Your Honors, the thrust of my case is fundamentally whether Mr. Johnson received a fair trial. This is a single eyewitness identification case in which the eyewitness gave varying accounts of the shooter and was impeached with his own credibility issues. There were errors throughout this case, including from the beginning when the government struck the 2 remaining Black jurors from the panel in violation of Batson v. Kentucky. And then the unrebutted evidence at his 23-110 hearing was that Mr. Johnson's trial attorney failed to investigate alibi witnesses in this single eyewitness case, which was deficient performance and caused Mr. Johnson harm or prejudice, As for these errors, I'm asking for the court to reverse Mr. Johnson's convictions. I'll address the other claims of error if the court wishes, but I'd like to preliminarily begin with the Batson challenge.
Why do you think that we can consider the Batson challenge again within the context of a direct appeal? And, you know, I understand that Mr. Johnson has been resentenced. Nonetheless, we have an opinion by a division of this court that has said there was no Batson problem. And I'm not sure I understand why you think another 3 judges can reach a different conclusion in effectively the same case.
Yes, Your Honor. Actually, preliminarily, the panel composition is 2 of the original judges and then the chief judge replacing Judge Nebaker. As a footnote, I don't know if Judge Nebaker recused himself because I was his former law clerk. And if that's the case, then just sort of by the unlucky draw of Mr. Johnson having me as appointed counsel has changed the composition of the panel. But nevertheless, you know, the thrust of my argument is that there has been an evolution in our thinking and in the law that should now include the consideration of implicit bias when we're looking at peremptory strikes. And so if the court was to rule that those jurors were either one of them were improperly struck based on a consideration of implicit bias, that would be a different ground for ruling.
So counsel, let me make sure I understand what you're saying. You're saying you're not actually trying to bring the same Batson claim that was decided and rejected in Mr. Johnson's initial direct appeal. You're bringing a different sort of claim.
Correct, Your Honor. You know, I would admit that I believe that the dissent in the first appeal was correct, but in looking at how our evolution on thinking on what does it mean to be racially conscious, what does it mean to have racial bias, the evolution on that thinking has changed so dramatically since his first trial 10 years ago that I think any evaluation on why a juror is struck, when you're looking at what's race neutral explanations, it has to also consider the fact that many of these race neutral explanations may also have an underlying implicit bias issue going on, which is why I cited to the Washington statute that has tried to be the first state to really kind of address those issues.
Right. And so if I could just jump in there, this argument, which you are saying is a new argument, was not made to the trial court, correct?
Correct.
So it's unpreserved and would be reviewable for plain error if we reached it.
I believe that's correct, Your Honor.
And so why would we say that this is plainly wrong? As you just acknowledged, you cited a court rule from Washington State. I didn't see any other authority from this jurisdiction or anywhere else in the form of an opinion. So that seems like an uphill battle to say that this was plainly wrong, such that the court should have sua sponte acknowledged, wait a second, there's implicit bias going on here, and that is cognizable under Batson. And so we have to strike this jury and start all over again.
Your Honor, it's really a situation where 10 years ago, the idea of implicit bias was sort of only in academia. It was sort of on the fringes, and now it's become really part of the justice system generally. There's judicial trainings on it now. There's recognition within the general public that we all hold these inherent biases and that we need to address them. So,
counsel, let me ask you, recognizing that you're talking about things that happened 10 years ago or so, implicit bias is by definition not apparent on the record. So what was it 10 years ago that alerted the trial judge to the argument that you're presenting to us now?
So, Your Honor, I think what alerted him then was that the government had then struck the last two remaining jurors. We know that because of defense counsel's statements. Then asked for the explanations. He actually disagreed with the explanation as to juror 442, that he did not see the demeanor that the prosecutor had noticed. But I think if he had gone further, if he had had that knowledge of implicit bias at the time, then he would have probed further. He would have asked additional questions about that demeanor. And looking at the Washington statute, they talk about when demeanor is offered, sort of the steps that you should take to try to safeguard against this. Batson is illusory in a lot of ways because race-neutral explanations can be very slippery and can be on its face racially neutral, but when you probe further, when you ask additional questions, it reveals itself that that's not actually a race neutral explanation. So I think if the trial judge had gone further, after he said, once he said, I don't believe I observed the same demeanor, he's rejected the race neutral explanation, and he should have asked further questions if that juror was going to be properly stricken.
But why do we judge his questions responding to the Batson challenge by today's standards?
I think in looking at the error, you want to have confidence in the outcome. And so it would be error to ignore what we now know and say that it was wrong then, but he didn't know it was wrong, so we're going to let the conviction stand. We have to, to serve justice, we have to incorporate the knowledge that we now have.
Counsel, where I'm really stuck is what I was discussing earlier is, and do you agree that this new argument is subject to plain error review under Alano and Puckett, right? And
Yes,
so under that analysis, right, the first step is there error, right? And let's assume for the sake of argument there was error. But the second question is it plain? And I'm sorry, is that the Washington State Authority, it's not a court rule, it's actually a statute. I mean, that seems even less helpful to you if a legislature has gone out and decided to incorporate this new conception of how jury discrimination in the selection of juries should be assessed, right? I mean, we don't have there. It seems like it's a singular statute in one jurisdiction that's 3,000 miles away. We don't have any authority from a court saying this is really how a Batson analysis or some sort of, addendum to a Batson analysis must be done. And just seems like under a plain error review, I don't understand how this claim can prevail.
Your Honor, I acknowledge that it's certainly an uphill battle. I think that in looking at plain error, it strikes me as wrong to say we now know that that was improper, but we just can't do anything about it because his attorney didn't object, his attorney didn't make those arguments, when that attorney necessarily wouldn't have made those arguments back then. But ignoring the evolution is an injustice. And yes, you're right, it's only one state, but it has to start somewhere. And we could also be incorporating this in a way that really kind of gives teeth to Batson. But Your Honors, if I've kind of summarized my argument enough, I would like to move on to the 23-110 issue, given my time limitations. Your Honors, the court found in their credibility determination, the court found the sisters that testified credible, but he said that they would have been impeached because of the passage of time and because of the relationship of Mr. Johnson. And I would say that had they been called originally, they wouldn't have been impeached by the passage of time. Then you would have only had the issue of a close family friendship to contend with. And Mr. Gladden, the complaining witness, also had his own credibility issues. Ultimately, the government in its closing arguments, they conceded there was no evidence of Mr. McCantz's investigation, but they said, court,
Counsel, if we could get to the point that's important to me.
Sure.
The sisters had the dates wrong. And so even if they had testified earlier, you'd still have the same problem. He was not arrested, apparently, on the date of the shooting.
Your Honor, I believe that there's actually some confusion in the testimony. When Mr. Johnson testified, I think that there was confusion there on what his timeline was. And I think that's sort of in line with Jones versus United States, which is where they talked about the context and tenor of testimony could have suggested confusion. And I think that ultimately, if this had been investigated initially, then we wouldn't, they would have figured it out early if it matched or not. I think that he was confused.
And so what, have tailored their story to the facts? Or isn't this a factual matter that the trial judge considered? And what gives us the right to interfere?
Well, Your Honor, the trial judge did not ultimately rule that the alibi wasn't an alibi. His ruling was based on the fact that they would have been impeached and that assuming that there was deficient performance, when he got to the prejudice prong, he said, even if the sisters had testified, it wouldn't have overcome Mr. Gladden's testimony about eyewitness ID and motive. So I don't think—
Well, counsel, I'm going to interrupt you there. I mean, the judge did say after noting, look, it's beyond credible that Mr. Johnson would have sat on this information, that he had two alibi witnesses throughout trial, throughout the first sentencing, throughout the resentencing, and the 10 years in between, right? I mean, so the judge just did not believe that he had told his lawyer about these witnesses. But beyond that, he said the real problem with the alibi is that it doesn't establish an alibi, right? You've got one sister saying, you know, it was just a barbecue. I kind of don't know when. I remember him being at a barbecue, kind of at a free floating point in time. And then you have the other sister saying, I remember him being at a barbecue and being arrested from the barbecue, which is clearly unhelpful because the date of his arrest is 2 days after the shooting. So that sister's testimony does not support an alibi. And the first sister's testimony doesn't really either, because it's so, you know, untethered in time and space. It doesn't show that, you know, I think that the court could say, I'm not going to hold, you know, I'm not going to upend this conviction based on that.
Your Honor, I recognize my time is waning, so
You
if I
can answer the
respond.
question.
So I think when your reference to where he says it doesn't provide an alibi, it's followed up by because Mr. McCants hadn't filed the notice pre-trial to give notice of that. So when you read the transcript as a whole, the trial court is really focused on finding Mr. Johnson incredible and finding the sisters credible. But the reason that he finds him incredible is based on the length of time and not writing to the judge and raising this issue earlier. He doesn't say he finds him incredible because the timeline doesn't match. So you know, that's his basis.
All right, counsel. We will give you a few minutes in rebuttal, and we'll hear from Mr. Sable now.
Thank you, Your Honor.
Mr. Sable, you're still muted. Maybe you know that. I can't hear you. There you go.
Good morning, Your Honor. Hi. I think I was
Good
muted. Turning to David Sable on behalf of the United States, turning first to the question of the two witnesses, the O'Brien sisters who testified. Your Honor, I have at pages 40 and 52, both O'Brien sisters saying that appellant was arrested at this very specific barbecue where they went to the Giant in the water balloon fight, which the party stipulated that the arrest was 2 days later. So that's why, as the court noted Judge Rankin's specific statement, the alibi wasn't in fact an alibi at all. And so for that fact alone, that finding alone, there was no prejudice because there was no alibi. Turning to the Batson claim, just as a factual matter, both judges here may recall we had some discussion about whether there were in fact any African-American jurors on the panel in the trial. And in fact, the court noted in the first footnote that we didn't know the racial composition. So there has been a statement by appellant that the two remaining Black jurors were struck, but in fact, we don't know. The record doesn't show whether that in fact is true, the final composition of the panel. And so I would make that note. But in any event, I'm not aware of any cases that would show plainly or any authority at all that that there was plain error here, as Judge Easterly was noting. I would also note that it's not clear under Colley Long and Magwood that claims of trial error can be raised on direct appeal from a resentencing. Obviously, Colley Long and Magwood are both collateral attack cases that construe textually the meaning of second or successive. I'm not going to tell Judge Easterly about Colley Long. I know you wrote the opinion, but it's not clear on direct appeal from a resentencing whether claims of trial error are cognizable. And so, but even if it is cognizable and it is a new claim and not barred as law of the case, which we think it is, because it's styled as a Batson claim, we don't have any plain error, and appellant hasn't met his burden. And I would note, as Judge Fisher was, I think, suggesting, not only do we not have the sufficient legal authority, but we don't have the factual development that we would need to have to even begin to grapple with this claim. I think counsel noted, I think if the trial judge, had gone further, well, we just don't know what would have happened if we were to try to apply some sort of Washington state rule here. And again, we don't have any authority for thinking that that is constitutionally compelled or the rule that this court should apply.
Counsel, can I just ask you about this sentencing enhancement issue?
Yeah.
And I'll return to Ms. Cuniff as well on this. But in a footnote at the very end of your brief, you make the point, or the government makes the point, that enhancement, the procedures for enhancement under 23-111 just don't apply when the actual sentencing exposure is not increased. And I thought that we had endorsed that thinking in Judge Fisher's opinion in Gray, which is a 2016 case. And I know I'm hitting you with this out of the blue, but I'm wondering if you had occasion to look at that case before this argument. And my thinking is, if you consider the purposes that we've discussed of the 23-111 procedure, which is to allow a defendant to make an informed decision. Am I going to plead guilty? Am I going to go to trial? Right. And so that's why the notice has to be given before you go to trial. Right.
Yes.
If you consider those purposes, and if a defendant has been indicted on charges where his exposure is, 25 years, hypothetically, then, if the enhancement is not going to, well, I guess 30, it has to be 30 years. His exposure is 30 years as it is in this case, and the enhancement allows an enhanced sentence up to 30 years. Then I'm not sure I understand how the enhancement would affect his decision-making at all, because he's simply being sentenced within the same range that he knew he would be sentenced before he went to trial.
I think that's right, Your Honor. I haven't seen Gray. I do try to read up because I know that you often hit me with cases I haven't read before. But the record tends to show that Judge Rankin didn't consider any enhancement of the sentencing guidelines in his sentence. If you look at the initial sentencing and you look at the resentencing, Judge Rankin focused very much on the traditional sentencing factors and didn't mention the sentencing guidelines when he imposed his sentence. He acknowledged that they had been calculated in the PSR. But
can I just interrupt you there? I mean, the guidelines discussion, that's where I get a little confused, because I kind of wondering what the guidelines have to do with anything, right? I mean, it's always the case that when you're calculating a defendant's guidelines that you're going to factor in prior convictions, right? That is just part of the algorithm. But my understanding is that the 23-111 statute is really about kind of exposure under the DC code. And we want people to have full information before they decide to go to trial. So I maybe you can explain to me why the guidelines are relevant, but and here I think it is confusing because the government persists in presenting the enhancement papers, and there's a conversation at the resentencing about what's in the enhancement papers. Nonetheless, it seems like all of that is kind of a moot point because the exposure is the same, and that's what I'm trying to sort out in my head.
If I understand your question correctly, as a factual matter, the enhancement increased the sentencing guideline range for the aggravated assault while armed charge, but it did not increase the statutory range because the statute was already at 30 years. So it only affected Mr. Johnson's guideline range for the one count. You're absolutely right, of course, that what effective notice means, as this court has said, for example, in Coleman, is that a defendant heading into trial, not at sentencing, but at trial, knows that he may face, if convicted, an enhanced sentence by virtue of this notice that the government has given him. And here, what we know is that the government noticed aggravated assault while armed. The actual conviction was assault with significant bodily injury. And appellant knew about the correct offense because Mr. Murder said that he did. And so he had effective notice. He's never challenged the validity of that. And so Coleman is directly on point here, which is a case where the government noticed armed robbery. The actual conviction on that date was robbery. And the court held that because he knew at trial, before trial, that he faced an enhanced penalty and he knew what the crime was, that he had effective notice, and then he could have that calculus about whether to go to trial or plead guilty. We're exactly in that same situation here. With respect to
Counsel, sorry, just to interrupt. I mean, I guess maybe the way I should ask my question is, have we ever said that notice under 23-111 requires notice about what your guideline range is going to be versus notice about what your sentencing exposure under the relevant provisions of the DC code are going to be?
I understand, Your Honor. I didn't understand that part of the question. I'm
No,
not
I
aware
think that the question just formulated in my head. So
I don't know the answer to that. The 23-111 has to do with inquiring and advising, of course. That's the plain error claim that appellant's raising, the procedural irregularity. Judge Rankin failed to inquire and advise. And I don't know if the court has ever said guideline ranges must be inquired about as opposed to statutory ranges. I would have to look at that, but I could look at that and then file something with the court.
I mean, when are guideline ranges determined, right? I thought that they weren't assessed until after trial, right? Isn't that when the PSR is written and right? So
Yes.
It just seems like there's a temporal mismatch too, because this notice is supposed to be provided before trial, at which point you might not know what the guideline range is because you haven't done that work yet, or that the agencies responsible for doing that work haven't done it yet.
That's right. I know in the district court context, parties entering a plea, for example, try to calculate the guideline range. And of course, the regime is different there. But of course, it's always subject to the final calculation by the pre-sentence report writer, by the court. Again, I see the court's point. I think the point is usually has to do with the statutory range. And we want the defendant to know that he or she will face an enhanced sentence if convicted by virtue of this notice. But I know I'm not answering the court's question specifically. I just don't know the answer.
This is helpful. Thank you. If you do you have any other points that you would like to make?
I don't, Your Honor. We would simply say that with respect to the allegation of trial error, the court's factual findings were not clearly erroneous, and for that reason, appellant hasn't shown either deficiency or prejudice, and therefore the court's ruling was not abuse of discretion, and asked the court to affirm the judgment in the Superior Court. Thank you very much.
Thank you, counsel. We'll give you about 3 minutes in rebuttal.
Your Honor, just to address the sentencing enhancement, I know you said you might come back.
I would like to get your view. Since you didn't address it in your initial argument, if you have thoughts, I'd appreciate them. Thanks.
So it's sort of interesting that the government files this notice saying that they're subject to an increased exposure when the maximum links up. And I do think that the court did rely on that notice in formulating its sentence, and sentenced him above what the government was actually asking for.
Rely in what way? The statute 1804A deals with increasing the ordinary statutory maximum. In what way did the court rely upon this notice?
So, Your Honor, I would have to go back into the transcript and give you particular sites, but the prosecutor made reference to the fact that they had filed that notice, and then the trial court did repeatedly sort of refer to his history with the justice system.
But
I
the court
understand that
could
that's-
take, the court could take that history into account, even if this notice had not been filed. And the court did not purport to give a sentence higher than 30 years.
Correct, Your Honor. No, not higher than 30 years, but higher than what the government requested. And I think it was informed by his view on Mr. Johnson's criminal history. As far as how gray is applicable, I'm in the same boat as Mr. Sable. So if the court would like supplemental briefing, I'm happy to do so on any issue. But Your Honors, as far as, excuse me. Your Honors, as far as the prejudice goes for Mr. Johnson when it comes to the 23-110, I do think that had we had Mr. McCants testify at that hearing and explain his process, if he had said, I did investigate them and I realized it wasn't an alibi, that would have been much different. But instead, we had no testimony defending his investigation at all. And what we ended up with was two sisters that the court did say they found credible. And
Counsel, who has the burden of proof at a 23-110 hearing?
the defendant has the burden of proof to show deficient performance. But the unrefuted testimony was that Mr. Johnson said, I told all these people, I told my attorneys and there was no investigation. The government didn't rebut that claim other than saying that he just should not be believed. I see that my time is up. Your Honors, I submit that Mr. Johnson was deprived of his constitutional rights to effective counsel and a fair trial. And the just outcome in this case is a reversal and a new trial where the government's evidence can be fairly tested in an adversarial process. Thank you very much.
Thank you, counsel, both for your arguments today. The case will be submitted. And at this point, you may leave the virtual courtroom and court will be adjourned.
This court is now adjourned.